In Abrams versus United States, the Supreme Court considered the constitutionality of limits on speech that allegedly posed a danger to the government during a time of war. Jacob Abrams and 4 other Russian nationals distributed pamphlets in New York near the end of World War I. The pamphlets protested the United States' actions in the war, including its deployment of troops in Russia. The pamphlets encouraged workers in munitions factories to strike to thwart American war efforts. Abrams and his fellow activists were convicted of conspiring to violate the Espionage Act and sentenced to between 15 and 20 years in prison. The Supreme Court granted a writ of error to evaluate whether the convictions violated the First Amendment. Justice Clark, writing for a 7-justice majority, upheld the convictions. The pamphlet's purpose was to incite sedition at the height of the war. Based on the court's earlier decision in Schenck versus United States, restrictions on that type of speech were constitutionally permissible because the speech posed a clear and present danger to the United States. Justice Holmes, joined by Justice Brandeis, dissented. In that opinion, Holmes wrote one of the most famous defenses of free speech. Only speech that posed a present danger of immediate evil could be restricted. Here, Holmes doubted that 2 pamphlets published by a handful of unknown dissidents could pose any immediate danger to the United States. In Holmes's view, Congress couldn't forbid all effort to change the mind of the country. He wrote, quote, "The ultimate good desired is better reached by free trade in ideas," unquote. In other words, only speech that imminently threatened immediate interference with the law should be checked. Abrams was one of a series of World War I-era Supreme Court cases that discussed the clear and present danger standard, which was first enunciated in Schenck. Justice Holmes had authored the court's majority opinions in Schenck, Frowork versus United States, and Debs versus United States, all of which upheld convictions for seditious speech under the Espionage Act. Thus, his dissent in Abrams was striking. It's worth noting that the convictions in these cases weren't rare at the time. The Attorney General reported over 800 convictions under the Espionage Act and similar laws in 1919 and 1920. Today, these cases still raise interesting questions about the nature and limits of free speech, and Abrams in particular is famous for Justice Holmes's invocation of the marketplace of ideas as a cornerstone of our constitutional system.